Good morning, everybody, and we welcome everybody back again, and especially Judge Kavanaugh and his wife, Ashley. Yesterday, each senator made their opening remarks. We also heard from three people who had the honor of introducing Judge Kavanaugh: Secretary Rice, Senator Portman, and Attorney Lisa Blatt. And we heard for the first time directly from Judge Kavanaugh. He made a powerful, compelling, and convincing statement demonstrating his exceptional background and qualifications to serve our nation's highest court. NBC News reported that Democratic members of the committee plotted with the minority leader to disrupt the hearing yesterday. Democratic senators interrupted the hearing 63 times before lunch. In the audience, 70 people were arrested yesterday who were following their lead. All probably very constitutionally prepared to do that, doing what the Constitution says, the right of freedom of speech, but we also were able to finally conduct our hearing the way it should be conducted. Yesterday was just opening statements. It was only our time as committee members that we wasted on disruption and disorder over procedural matters. But today is different.
Going all day.
Your advice was to waive.
My advice was just yes.
Okay.
Senator Grassley, I take offense. I called out Senator Durbin. I don't see how you can say that I was working with Senator Durbin. I'm from his state and I called him out specifically. That we are not working with the Democrats. We are working for ourselves, not an individual disability.
It was our time as committee members yesterday to make our case. Today is different. Today is the day that the American people are supposed to hear from the nominee. This morning, we'll begin our questioning of Judge Kavanaugh. We will get through all members' first rounds of questions today, no matter how long it takes. Members are allotted 30 minutes for the first round. If your time expires, your remaining questions may be continued, of course, in the second round tomorrow. We'll take a lunch break, as well as probably 2 other 15-minute breaks throughout the day. For now, let's plan our first break after 5 senators or so have completed their questions. I assume that this will be around 12:15, which will hopefully coincide with the floor vote that's already scheduled. This would be a 3-minute or 30-minute break for vote and lunch. But Judge, if you would like to take a break any other time, let us know. We're happy to accommodate that. And with that, I will start the questioning of my 30 minutes. Judge, for the last 12 years, you have served as a federal circuit judge on one of the most influential circuits in America. You have offered 307 judicial opinions and joined hundreds more, totaling more than 10,000 pages of record. You have decided some of the most pressing legal issues facing our country. The Supreme Court of the United States, the one you're nominated to be on, has adopted a legal position, your legal position, from at least 12 opinions. The Senate Judiciary Committee has received dozens of strong letters of support from hundreds of people, many of whom you know best, from all across the political and ideological spectrum. And the American Bar Association has given you its highest rating, unanimously well qualified. My Democratic colleagues have said that this is the gold standard of judicial nomination. There is no dispute that you're one of the most qualified Supreme Court nominees. Some people say the most qualified, and I don't disagree with their judgment. And that could be for anybody coming before the United States Senate. I'm not the only one who says that, because we have a letter from Robert Bennett, surprisingly, President Clinton's attorney, and your opposing counsel during the independent counsel investigation of President Clinton. He wrote a very strong letter in support of your confirmation. Quote, Brett is the most qualified person any Republican president could possibly have nominated. Were the Senate to fail to confirm Brett, it would not only mean passing up the opportunity to confirm a great jurist, but it would also undermine civility in politics twice over. First, in playing politics with such an obviously qualified nominee, and then again in losing the opportunity to put such a strong advocate of decency and civility on our nation's highest court. Mr. Bennett also speaks highly of your integrity and to your fairness and open-mindedness. And so without objection, I would enter that letter in the record. Now to a question. I imagine that your 12 years of judicial service on the second highest court in the land has given you plenty of opportunity to think about my first question, which is, what makes a judge a good one, and what influences in your life have shaped your vision of how a judge should go about doing his job?
Thank you, Mr. Chairman. I think the first quality of a good judge in our constitutional system is independence. Independence comes directly from Article 3 of the Constitution. The independence of the federal judges really is guaranteed by the framers in our life tenure and our protection from pay reduction. So because we have life tenure, we are independent and immune from political or public pressure. So I think the first thing that makes a good judge is independence, not being swayed by political or public pressure. That takes some backbone. That takes some judicial fortitude. The great moments in American judicial history, the judges had backbone and independence. You think about Youngstown Steel. You think about, for example, Brown versus Board of Education, where the court came together and knew they were going to face political pressure and still enforce the promise of the Constitution. You think about United States versus Nixon, which I've identified as one of the greatest moments in American judicial history, where Chief Justice Burger, who had been appointed by President Nixon, brought the court together in a unanimous decision to order President Nixon in response to a criminal trial subpoena to disclose information. Those great moments of independence and unanimity are important. Respect for precedent is another one. We are a system of constitutional precedent. Precedent is not just a judicial policy. It's sometimes stated that it's just a policy. Precedent comes right from Article 3 of the Constitution. Article 3 of the Constitution refers to the judicial power. What does that mean? What does judicial power mean? Judicial power, you look at Federalist 78, and what's described there is a system of precedent. So precedent is rooted right into the Constitution itself and is constitutionally dictated to pay attention and pay heed to the rules of precedent. Beyond that, being a good judge means paying attention to the words that are written, the words of the Constitution, the words of the statutes that are passed by Congress, not doing what I want to do, not deferring when the executive rewrites the laws passed by Congress, but respect for the laws passed by Congress, respect for the law, the words put into the Constitution itself. That's part of being a good judge. That's part of being independent. That's part of precedent. And then I would say being a good judge, there are human qualities in terms of the interaction. Although these confirmation processes focus on one person, as if you're making all the decisions, as I said yesterday, I'm joining a team of 9 if I were fortunate enough to be confirmed. And that means something. It means something in sports. It means something in judging. I don't make decisions by myself. For the last 12 years, I have not been making decisions by myself. Every case has been in a panel of at least 3 judges. And you learn from each other when you're deciding cases. You work with each other when you're deciding cases. And so having collegiality and civility, as Justice Kennedy showed us so powerfully, repeatedly, with how he conducted himself over the years. That's very important, because those great moments that I was talking about at the beginning, like United States versus Nixon, like Brown v. Board, the court came together in unanimous decisions, and the unanimity of the decisions added force. That took personal interaction, that took collegiality. So I think, I've tried to be a very collegial judge. I've tried to be civil. I want, Mr. Chairman, the losing party in every case to come out and say, Kavanaugh gave me a fair shake. He was well prepared. He wrote a clear opinion. He explained everything. I disagree, but at least I get it. So I want the losing party, and I want both parties to walk out at oral argument and say, he had an open mind, he gave me a fair shake, and I think I've done that for 12 years. I've tried to do that consistently. Everything you do as a judge matters in terms of being a good judge. Oral argument, writing opinions, how you decide. So those are the qualities. I guess the last thing I always remember about it is the thing I said my mom taught me in the first instance. Judging is not just about theory. It's not theory. It's not just what a law review article is. Judging is real people in the real world, and every decision we make, no matter how high-minded it might sound, affects real people in the real world with real interests. And we have to remember that in how we explain the decisions. Thank you, Mr. Chairman.
Now, following up on the wise words of Senator Sass yesterday on separation of powers, your record before the Senate includes more than 10,000 pages of judicial writings over your dozen years. We have over 440,000 pages of emails and other records from your legal service at the White House and Judge Starr. And you have written extensively on the issue of our Constitution's separation of power among the 3 branches. A key component of the separation of powers is the independent judiciary. Obviously, everybody learns in 8th grade civics about judges interpreting law. The judiciary must continue to be the least political and least dangerous branch. A judge's sole job is to find and apply the law evenly and fairly, without regard to the president who nominated him, the senators who voted for him, the parties before him, and the political consequences of his judicial decision. So, Judge, let's discuss judicial independence from the executive branch. No one, not even the president, is above the law. Some of my colleagues have criticized your views of presidential authority, suggesting, wrongly in my opinion, that your views of presidential authority would not allow any meaningful check on the president, particularly this one. Please tell us what judicial independence means to you, including whether you have any trouble ruling against the president who appointed you and against the executive branch in any case before you. You partly talked about independence, but apply it specifically to a ruling against the president or the executive branch generally.
Thank you, Mr. Chairman. To begin with, you're correct. No one is above the law in our constitutional system. Federalist 69 Hamilton makes clear all the ways that the executive branch, as designed by the framers of the Constitution, was different from the monarchy. Under our system of government, the executive branch is subject to the law, subject to the court system, and that's an important part of Federalist 69. It's an important part of the constitutional structure. In general, so too, we as judges are separate from the Congress. We are not supposed to be influenced by political pressure from the executive or from the Congress. We are independent. We make decisions based on law, not based on policy, not based on political pressure, not based on the identity of the parties, no matter who you are in our system, no matter where you come from, no matter how rich you are or how poor you are, no matter your race, your gender, no matter your station in life, no matter your position in government. It's all equal justice under law. And again, look at our examples in history. I always will go back to the great moments in our history where these principles, which sound abstract if you're just describing them, were actually implemented. And I go back to Youngstown Steel. And you think about, it's a 6-3 decision where the Supreme Court rules that President Truman has violated the law by seizing the steel mills. Now, this is a time of war where lots of Americans were killed, and the Supreme Court's under pressure to defer to the president's war effort. And a 6-3 decision, but what's interesting to me, Justice Clark, you don't usually talk about Justice Clark in that decision. Why is he important? He's important. He was appointed by President Truman to the Supreme Court. What a moment of judicial independence there to rule in that case. You think about Justice Jackson, who had been working for President Roosevelt, and then he dissents in the Korematsu case. Stands up and says, letting racism like this is like letting a loaded weapon lie around. Dissents against President Roosevelt's decision. Justice Jackson's...
Ask him to suspend.
Justice Jackson's concurrence in Youngstown, which is, of course, what has become the law, that 3-part test, Category 1, Category 2, Category 3. But again, he writes that concurrence in Youngstown. Why is that a moment of judicial independence? He had taken positions contrary to that when he had worked in the executive branch in the Roosevelt administration, yet when he's a judge, he sees it differently as an independent judge. How about Chief Justice Berger? United States versus Nixon. Writes the opinion. Unanimous. Moments of judicial independence. So it's resisting public pressure, political pressure. It's treating everyone equally, no matter where you are, what station. When I was became a judge on the D.C. Circuit, I had a case called Hamdan versus United States. Who's Hamdan? So in the Hamdan case, Hamdan's one of bin Laden's associates. You will never have a nominee. Chairman, should I proceed?
Yeah. This is coming out of my time, but that's okay. Let these people have their free speech and interrupt the other 300 million people. Listen, that this is your opportunity to speak to the American people and for them to make a judge about it. If they want to affect what the other 300 million people hear from you, then that's just too bad. You proceed now.
Hamdan's one of bin Laden's associates involved before September 11th, worst attack ever on American soil. He's prosecuted before a military commission, signature prosecution of the Bush administration. Comes to the D.C. Circuit. I'm on the panel. I write the opinion saying that his military commission prosecution is unconstitutional, violates ex post facto principles. You'll never have a nominee who's ruled for a more unpopular defendant than ruling for Salim Hamdan. And why did I do that in that case? Why did I rule for someone who had been involved in the September 11th? It's because the law compelled it. As Justice Kennedy showed us in the Texas versus Johnson case. We don't make decisions based on who people are or their policy preferences or the moment. We base decisions on the law. Justice Kennedy's example of independence is something I've tried to follow. And it means, you know, you're not a pro, as I said yesterday, not a pro plaintiff or pro defense judge, not a pro prosecution or pro defense judge. I'm a pro law judge, and I've ruled for parties based on whether they have the law on their side. That's part of being an independent judge, is ruling for the party no matter who they are, so long as the party is right. If you walk into my courtroom and you have the better legal arguments, you will win.
I think you answered my next question based upon what you said about Hamdan, but there's probably other examples. You don't need to go into detail, but you have President. President Bush appointed you. Are there other cases that there's been other cases, presumably you've ruled against the administration of the person that appointed you?
Absolutely, Mr. Chairman. There were a slew of cases on everything from Freedom of Information Act to some of the administrative law cases. The Hamdan one is certainly the one that comes to mind most because of the importance of that case, yet I ruled that it was unlawful.
Yeah. Now, did anyone ask you to make any promises or assurances at all about the way that you would rule in certain cases?
No.
Were you asked about your views on Roe v. Wade?
No.
We're talking about separation of powers. Have you ever written any decisions where you use the 10th Amendment? I'm talking about division of powers between federal and states.
Mr. Chairman, most of the cases that come to the D.C. Circuit are at the national level and therefore involving questions of separation of powers between the legislative, executive, and judicial branches. Of course, federalism is a critical part of our constitutional structure as well. The genius of our system, Federalist 39, as described by Madison, is that we have both a national government and a federal government simultaneously. And the House of Representatives really represents, in some ways, the national part, proportional representation. This body, with 2 senators from each state, represents, in many ways, the federal part, each state represented equally. And the federalism system by which the states are allowed to regulate local matters. In some of the Commerce Clause cases, such as United States versus Lopez and United States versus Morrison, reinforce the idea that there is a core of authority that is exclusively in the province of the states and beyond the scope of the federal government. The 10th Amendment reinforces the structure of federalism that's in our constitutional system. It's important always to remember the role of the states in our constitutional systems, and it's important to recognize as individual citizens something we often forget, particularly in a process like this. Our rights and liberties are protected by the federal Constitution and by the federal courts, but they're also protected by state constitutions and state courts. A great judge on the Sixth Circuit, Judge Jeff Sutton's written a new book about using state constitutions to help protect your individual liberties and rights too. This whole document, through the separation of powers and the federalism, tilts toward liberty. Okay.
Now, we've talked about your independence from a president. There's also the question of independence from the legislative branch, equally as important. You're going to be asked about your personal views on a variety of topics and whether you believe various Supreme Court cases were correctly decided. Presumably, this is because senators are going to try to predict how you'll rule in cases before you. The idea is that if they agree with your personal views on particular issues of morality or on Supreme Court precedent, they maybe would vote to confirm you. If not, they might not. Of course, that's improper. Judges should never promise their future votes on the bench in exchange for a senator's vote for them. If you answer these questions about your views on specific Supreme Court cases or public controversies of the day, you'd be showing the opposite of independence from the legislative branch. Politicians can make promises about how they'll vote on issues. Judges, by the very nature of the job, should never promise any outcome. If a nominee answers these questions, it threatens to undermine judicial independence. Of course, there may be times where it's appropriate to reconsider certain decisions, especially if more recent opinions have called into question the rationale of the original decisions. So, with this in mind, I'd like to explore the approach that you'd take towards Supreme Court precedent. Could you tell us your views on the value of precedent? I think you've already done that. But if you want to expand on it, go ahead. Have you ever followed precedent of the Supreme Court when doing so conflicted with your personal beliefs?
Well, my personal beliefs are not relevant to how I decide cases. The role of precedent in our system, which I said is rooted in Article 3 of the Constitution, it's not just a judicial policy. The role of precedent is to ensure stability in the law, which is critically important. It's also to ensure predictability of the law. People who order their affairs around judicial decisions need to know that the law is predictable. Whether you're an individual or a business or a worker, you need to have predictability. People rely on the decisions of the courts. And so reliance interests are critically important to consider as a matter of precedent. They are one of the reasons we have the system of precedent, so that people can rely on the decisions. Precedent also reinforces the impartiality and independence of the judiciary. The people need to know in this country that the judges are independent and that we're not making decisions based on policy views. Part of that is to understand we're following a system of precedent of what has been done before. The court, every time someone gets on, it's not just bouncing around to what do I think's best. It's what's the precedent of the Supreme Court is always part of the analysis, an important part. And for 12 years, I've been applying precedent of the Supreme Court and of my court. Every day for 12 years, I haven't been getting up saying, how can I rewrite the law? I've been getting up for 12 years every day saying, okay, how can I apply this Fourth Amendment precedent to this fact pattern that comes before me? Or how can I apply this First Amendment precedent to this fact pattern that comes before me? So precedent is the foundation of our system. It's part of the stability. It's ensuring predictability. And it's just foundational to the Constitution, as Article 3 and Federalist 78 make clear.
Now you'll be asked by other members which Supreme Court precedents you like and don't like, but as you know, it's inappropriate for a nominee to answer those questions. And this refers to Justice Ginsburg. She said, quote, "A judge sworn to decide impartiality can offer no forecasts, no hints, for that would show not only disregard for the specifics of a particular case, it would display disdain for the entire judicial process," end of quote. The underlying reason for this, of course, is that making promises or giving hints undermines the very independence that we've discussed. Would you agree with that?
I do, Senator, Mr. Chairman, and one of the things that I have to remember sitting in this seat is that this moment is a moment of judicial independence with how I interact with this committee. And what I've done in each of the jobs I've had, and particularly as a judge over the last 12 years, but also in the executive branch, I always ask myself, and I tell people I'm working with to ask, how has it been done before? How has it been done before? So as a judge, how has it been done before is precedent. That's how's it been done before. When I'm sitting here, what did I do? I went and studied all the nominee precedent. I've read Thurgood Marshall's hearing and Justice Brennan's hearing, and I've read the hearings of the 8 justices currently sitting on the Supreme Court. It's what I call nominee precedent. And so all the nominees currently sitting on the Supreme Court, all the justices, have made clear a couple things. First of all, they can't discuss cases or issues that might come before them. As Justice Ginsburg said, no hints, no forecasts, no previews. That also means, with respect to at least the vast body of Supreme Court precedent going back, you can't give a thumbs up or thumbs down on the case. That's Justice Kagan's formulation. She said repeatedly, no thumbs up or thumbs down when she was asked, what do you think about this case? What do you think about that case? I liked her formulation there, no thumbs up or thumbs down. That nominee precedent, as I call it, is now, in my view, part of the independence of the judiciary. And that nominee precedent is something I need to adhere to when I am here as a nominee now, because that's one of my jobs here is not to advance my own interest, but remember I'm a representative of the judiciary as a whole, and I have a responsibility to judicial independence right here, right now as a nominee. So following that nominee precedent is going to be critical. Now there's an exception that the 8 justices have drawn currently sitting on the court, if you read all the hearings, for some older cases, and I'll be happy to use some older cases where nominee precedent does allow the justices, has allowed them to talk about a few older cases. And again, why do we do this? Why is this nominee precedent there? When 8 justices of widely ranging views do this, there must be a reason. The reason is judicial independence. What does that mean? It means 2 things in this context. One, the litigants who come before us have to know we have an open mind, that we don't have a closed mind, that we haven't committed something in this process that is going to affect how we decide a case because we feel bound by what we promised to this committee. And believe me, judges do feel bound by what they said to this committee. So if I say something and the case comes before me 5 years from now, I'm going to feel morally bound by what I said here. And if I've crossed the line of what I should say, then I'm not going to have an open mind in that case. That's a violation of judicial independence. Secondly, as Chief Justice Roberts described perhaps better than anyone, if I get into some kind of process that appears to be a bargaining process where I say, well, I'll agree with this decision in exchange for your vote, it's never that explicit. But that's, as Chief Justice Roberts described it, that's kind of the what seems to be going on sometime. Well, that's a complete violation of judicial independence, because then the judges aren't making the decisions based on their reading of the law. It's really, as Chief Justice Roberts described it, it's the Senate or the Senate Judiciary Committee really sending a nominee as a delegate to the judiciary and really doing what the Senate Judiciary Committee thinks is the right thing to do. Chief Justice Roberts explained very forcefully that doing that would be a violation of judicial independence. That nominee precedent weighs heavily on me as a nominee here. Because it's rooted in judicial independence, and I've said repeatedly already that I'm going to be an independent judge. Well, I have to be an independent nominee as well, so I'm going to have to adhere to the lines drawn by those prior nominees, Mr. Chairman.
With only 25 seconds left, I'm going to reserve that time and go to Senator Feinstein.
Thank you very much, Mr. Chairman. Good morning, Judge.
Thank you.
I'm sorry about the circumstances, but we'll get through it. I wanted to talk to you this morning about guns and go back to Roe v. Wade, if I might. My office wrote the assault weapons legislation in 1993. It was law from 94 to 2004, and it essentially prohibited the transfer, sale, and manufacture of assault weapons. It did not, at the time, affect possession. I happen to believe that it did work and that it was important. And I have watched case after case, and I think I mentioned earlier, school shootings, which are just, I never thought this would happen in our country, that someone would bring a semi-automatic assault weapon into a school and just mow down children and staff. And so I've been very interested in your thinking on assault weapons. You specifically argued that the DC assault weapons ban was unconstitutional, and I think because you said these weapons were in common use. What did you base your conclusion that assault weapons are in common use, and what evidence or study did you use to do that?
Thank you, Senator Feinstein, for the question. And I understand, of course, your role on that issue and your long leadership on that issue, and appreciate that. I faced a decision where, as in every other decision just about on the DC circuit, I had to follow precedent of the Supreme Court. I don't get to pick and choose which Supreme Court precedents I get to follow. I follow them all. And so in the Second Amendment context, the Supreme Court in the Heller decision, written by Justice Scalia, had held that there was an individual right to keep and bear arms. And then in explaining what that meant and what exceptions would be allowed to that right, Justice Scalia's opinion for the court in Part 3 of the opinion went through, this does not mean that there's no gun regulation permissible. So that was an important part of the opinion, Part 3 of the Supreme Court's opinion, where it pre-identified a number of exceptions that would be allowed. Felon in possession laws, concealed carry, laws, possession of the mentally ill, possession of guns in schools, possession in certain kinds of buildings. He pre-identified that. As to the weapons, the way I understood what he said there and what was said in the McDonald case later was that dangerous and unusual weapons could be prohibited. And what he referred to specifically is machine guns could be prohibited. So it's very important to recognize under the Heller decision, machine guns can be prohibited. And
they were in the Firearms Act a long time ago.
Yes, and that's
have been prohibited.
Yes, Senator, and Justice Scalia's opinion did not disturb that long-standing regulation. In fact, specifically reaffirmed that machine guns could be prohibited. The court in Heller, the Supreme Court, upheld or struck down a DC ban on handguns, most of which are semi-automatic.
I don't mean, let me interrupt you because I think we're on totally different wavelengths. I'm talking about your statement on common use, as common use being a justification, and assault weapons are not in common use.
And Justice Scalia's opinion used that phrase. Then I think the next sentence of the opinion talked about dangerous and unusual weapons, and the court in Heller itself, the Supreme Court, struck down a DC ban on handguns. Now, most handguns are semi-automatic. That's something that not everyone appreciates. Most handguns are semi-automatic. And the question came before us of semi-automatic rifles, and the question was, can you distinguish as a matter of precedent? Again, this is all about precedent for me, trying to read exactly what the Supreme Court said. And if you read the McDonald case, and I concluded that it could not be distinguished as a matter of law, semi-automatic rifles from semi-automatic handguns, and semi-automatic rifles are widely possessed in the United States. There are millions and millions and millions of semi-automatic rifles that are possessed, so that seemed to fit common use and not being a dangerous and unusual weapon. That was the basis of my dissent. In a nutshell, the basis of my dissent was I was trying to follow strictly and carefully the Supreme Court precedent. And I know you've read the opinion.
You're saying the numbers determine common use? Common use is an activity. It's not common storage or possession, it's use. So what you said was that these weapons are commonly used. They're not.
They're widely possessed in the United States, Senator, and they are used and possessed, but the question is, are they dangerous and unusual? They're certainly dangerous. All weapons are dangerous. Are they unusual? And given how prevalent they are in the United States, it seemed under Justice Scalia's test, and if you look at the majority opinion in McDonald, the same thing. I want to reiterate, the Supreme Court made clear that machine guns can be banned. Machine guns can be banned.
Let me speak to you. I'm talking about the Heller case. Let me be specific. Mm-hmm. And you specifically argued that it was unconstitutional to defend assault weapons because they are, to ban assault weapons because they are in common use. And that, I believe, was your dissent in the case.
Yes, and I was referring to some kinds of semi-automatic rifles that are banned by D.C. are widely owned in the United States. And that seemed to be the test that the Supreme Court had set forth in the Heller and McDonald cases. In other words, if a type of firearm is widely owned in the United States. Now, whether I agree with that test or not was not the issue before me. I have to follow the precedent of the Supreme Court as it's written. And that's what I tried to do in that case. It's a very long opinion. I also made clear, Senator Feinstein, at the end of the opinion, I am a native of this area. I'm a native of an urban, suburban area where I grew up in a city plagued by gun violence and gang violence and drug violence. So I fully understand, as I explained in the opinion, the importance of this issue. I specifically referenced that Police Chief Kathy Lanier's goals of reducing gang and gun violence was something I certainly applauded, but that I had to follow the precedent of the Supreme Court in that case. And as I read it, that's what it said. I'm sorry.
How do you reconcile what you've just said with the hundreds of school shootings using assault weapons that have taken place in recent history? How do you reconcile that?
Senator, of course, the violence in the schools is something we all detest and want to do something about. And there are lots of efforts, I know, underway to make schools safer. I know at my girls' school, they do a lot of things now that are different than they did just a few years ago in terms of trying to harden the school and make it safer for everyone. Guns, handguns and semi-automatic rifles are weapons used for hunting and self-defense, but as you say, Senator, you rightly say, they're used in a lot of violent crime and cause a lot of deaths. Handguns are used in lots of crimes that result in death, and so are semi-automatic rifles. That's what makes this issue difficult. As I said in the last 2 pages of my dissent in Heller, I fully understand the gang violence, gun violence, drug violence that has plagued various cities, including Washington, D.C. This was known as the murder capital of the world for a while, this city, and that was a lot of handgun violence at the time. And so I understand the issue, but as a judge, my job, as I saw it, was to follow the Second Amendment opinion of the Supreme Court, whether I agreed with it or disagreed with it. At the end of the opinion, I cited Justice Kennedy's Texas versus Johnson quote, which I read yesterday as the guiding light for the lower court judges and all judges.
Let me give you a couple of other quotes because I'm going to change the subject. Do you agree with Justice O'Connor that a woman's right to control her reproductive life impacts her ability to quote, participate equally in the economic and social life of the nation, end quote?
Well, as a general proposition, I understand the importance of the precedent set forth in Roe v. Wade. So Roe v. Wade held, of course, and it's reaffirmed in Planned Parenthood versus Casey, that a woman has a constitutional right to obtain an abortion before viability, subject to reasonable regulation by the state, up to the point where that regulation constitutes an undue burden on the woman's right to obtain an abortion. And one of the reasons for that holding, as explained by the court in Roe and also in Planned Parenthood versus Casey more fully, is along the lines of what you said, Senator Feinstein, about the quote from Justice O'Connor. So that's one of the rationales that undergirds Roe v. Wade. It's one of the rationales that undergirds Planned Parenthood versus Casey.
Well, let me give you another one, rationale. In the 1950s and 60s, the 2 decades before Roe, deaths from illegal abortions in this country ran between 200,000 and 1.2 million. That's according to the Guttmacher Institute. So a lot of women died in that period. So the question comes, and you have said today, not today, but it's been reported that you have said that Roe is now settled law. The first question I have of you is, what do you mean by settled law? I tried to ask earlier, do you believe it is correct law? Have your views on whether Roe is settled precedent or could be overturned? And has your views changed since you were in the Bush White House?
Senator, I said that it's settled as a precedent of the Supreme Court entitled to respect under principles of stare decisis. And one of the important things to keep in mind about Roe v. Wade is that it has been reaffirmed many times over the past 45 years, as you know. And most prominently, most importantly, reaffirmed in Planned Parenthood versus Casey in 1992. And as you well recall, Senator, I know when that case came up, the Supreme Court didn't just reaffirm it in passing. The court specifically went through all the factors of stare decisis in considering whether to overrule it. And the joint opinion of Justice Kennedy, Justice O'Connor, and Justice Souter at great length went through those factors. That was the question presented in the case.
Could I interrupt you to say, since you mentioned stare decisis, and I sat on 9 of these hearings, and when the subject comes up, the person says, I will follow stare decisis, and they get confirmed, and then of course they don't. So I think knowing going into it, how you make a judgment on these issues is really important to our vote as whether to support you or not, because I don't want to go back to those death totals in this country. And I truly believe that women should be able to control their own reproductive systems within, obviously, some concern for a viable fetus.
Mm-hmm. And I understand your point of view on that, Senator, and I understand how passionate and how deeply people feel about this issue. I understand the importance of the issue. I understand the importance that people attach to the Roe v. Wade decision, to the Planned Parenthood versus Casey decision. I don't live in a bubble. I understand. I live in the real world. I understand the importance of the issue.
Well, my staff just passed me a note. Let me read it to you because I think it's a good. Have your views about whether Roe is settled precedent changed since you were in the Bush White House?
My
yes or no?
Well, I'll tell you what my views. I'm not sure what it's referring to about Bush White House, but I will tell you what my view right now is, which is an important precedent of the Supreme Court that's been reaffirmed many times. But then and this is the point I want to make that I think is important. Planned Parenthood versus Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent. It's not as if it's just a run-of-the-mill case that was decided and never been reconsidered, but Casey specifically reconsidered it, applied the stare decisis factors, and decided to reaffirm it. That makes Casey a precedent on precedent. Another example of that, as you might say, are there other cases like that, is Miranda. So Miranda's reaffirmed a lot, but then in the Dickerson case in 2000, Chief Justice Rehnquist writes the opinion considering the stare decisis factors and reaffirming Miranda, even though Chief Justice Rehnquist, by the way, had been a fervent critic of Miranda throughout his career. He decided that it had been settled too long, had been precedent too long, and he reaffirmed it. So precedent on, I'm sorry to interrupt.
I'm sorry to interrupt.
Thank you.
But I want to switch subjects, and one last question. What would you say your position today is on a woman's right to choose?
Well, as a judge,
As a judge.
As a judge, it is an important precedent of the Supreme Court. By it, I mean Roe v. Wade and Planned Parenthood versus Casey. Been reaffirmed many times. Casey is precedent on precedent, which itself is an important factor to remember. And I understand the significance of the issue, the jurisprudential issue, and I understand the significance as best I can. I always try, and I do here, of the real-world effects of that decision, as I try to do of all the decisions of my court and of the Supreme Court.
Well, I thank you for that. Let's go to presidential power for a moment. You were part of Ken Starr's independent counsel team, which conducted a sweeping investigation into possible wrongdoing by President Clinton and the First Lady. At the time, you argued for aggressive questioning of the president. You did not take the position that President Clinton was immune from investigation. Since then, you have taken the opposite position. In fact, you have said that, and I quote, "If the president were the sole subject of a criminal investigation, I would say no one should be investigating that at all." What did you mean by that? And what are the circumstances where a sitting president could be subject to criminal investigation?
And I appreciate the sign there. Senator, the last sign I should have mentioned while I was up, the Second Amendment sign actually had a brackets around part of my quote, and I'm not sure if it was the exact quote, but this one, I just wanted to point that out.
Is this accurate?
Here's what I was saying, Senator. Let me explain it. This one. The last one may or may not have been accurate. I just wanted to point that out for the record. It had brackets for my quote. This one. So what happens after the Starr investigation? Then I work 5.5 years in the White House. So let me just give you, if I can, some context here, and I'm going to get specifically to your question. So I work in the independent counsel investigation, and that is obviously difficult, controversial, a moment for our country that I wish hadn't happened. We all wish it hadn't happened. And I reflect on that. I wrote a Georgetown University Law Journal article in '99 reflecting on some of my thoughts about that. This seems to be a tendency of mine to go through an experience, write an article reflecting on it. And then I work in the Bush White House for 5.5 years. And I write an article in the Minnesota Law Review, Senator Klobuchar, in 2009, when President Obama's in office, I should point out. And I reflected on a number of things I had learned working in the independent counsel office and then working in the White House. And I thought there were a number of things Congress could take a look at that I had experienced. One of them was I proposed timelines for consideration of judicial nominees. I proposed a 180-day up or down vote for every judicial nominee. That was something that, from my experience, I thought would avoid controversy and have rules of the road set in advance, and I proposed that specifically for Congress to consider. Other aspects, I said, another thing I proposed was for Congress to consider whether it should look at Clinton versus Jones or the principle of Clinton versus Jones. So you call Clinton versus Jones and said a president is subject to civil suit while in office, the Paula Jones suit. That was a controversial decision, but the Supreme Court made clear at the end of the decision Congress could provide extra deferral of suits, not immunity, but deferral of suits for presidents if Congress so wanted. And so in the Minnesota Law Review article, I put out some ideas about whether Congress may want to think about that. And why did I do that? I think Senator Durbin asked yesterday, what changed that made me think about that? from the time. What changed was September 11th. That's what changed. So after September 11th, I thought very deeply about the presidency. And I thought very deeply about the independent counsel experience. And I thought very deeply about how those things interacted. And I thought very deeply about seeing President Bush when he came into the Oval Office on September 12th, 2001 in the morning. President Bush said, "This will not happen again. This will not happen again." And he was of single-minded focus. Every morning for the next 7 years for President Bush was still September 12th, 2001. Single-minded focus. And then thinking back to the independent counsel experience in August of 1998. So I proposed some ideas for Congress to consider. Here's the bottom line point. There were ideas for Congress to consider. They were not my constitutional views. If a case came up where someone was trying to say this is a constitutional principle, I would have a completely open mind on that, because I've never taken a position on the Constitution on that question. I've only put out proposals for you all to study, to think about the balance of a president fighting a war, leading a war, and a president subject to, say, ordinary civil lawsuits, as in the Clinton versus Jones case.
Let me ask you, you're becoming very good. You're learning to filibuster. But let me ask this question precisely. The Supreme Court has unanimously ruled that a president can be required to turn over information. It upheld the subpoena for the tapes of Oval Office conversations that revealed President Nixon's efforts to cover up the Watergate break-in. This, as you know, was U.S. v. Nixon. You have said that the Nixon case might have been wrongly decided. Was U.S. v. Nixon wrongly decided, in your view?
So that quote is not in context and is a misunderstanding of my position that's up there. I have repeatedly called U.S. v. Nixon one of the 4 greatest moments in Supreme Court history. So I've called that, the 4 I've always identified are Marbury versus Madison, Youngstown Steel, Brown versus Board of Education, and United States versus Richard Nixon. And why have I, Brown versus Board, by the way, the single greatest
Was
moment.
it rightly decided?
So I have said that, I've said yes, that the court's holding that a criminal trial subpoena to a president in the context of the special counsel regulations in that case for information, a criminal trial subpoena for information under the specific regulations in that case, I have said that holding is one of the 4 greatest moments in Supreme Court history. So not only I can explain how that misunderstanding came up, because I know there was a news story about that, and that's just not correct impression of my views. My views have been consistently. Why was it one of the greatest moments? It was one of the greatest moments because of the political pressures of the time. The court stood up for judicial independence in a moment of national crisis. That's what the Supreme Court, we need the Supreme Court to decide the things we can foresee. But one of the things that's really important for the Supreme Court, we're going to have crisis moments at the Supreme Court on things we can't even predict. And we need people on the Supreme Court who are prepared for that. And U.S. v. Nixon is...
My time's going to run out very quickly. Let me just ask you this. Can a sitting president be required to respond to a subpoena?
So that's a hypothetical question about what would be an elaboration or a difference from U.S. v. Nixon's precise holding.
That's right.
And I think going with the Justice Ginsburg principle, which is really not the Justice Ginsburg alone principle, it's everyone's principle on the current Supreme Court. And as a matter of the canons of judicial independence, I can't give you an answer on that hypothetical question.
So you can't give me an answer on whether a president has to respond to a subpoena from a court of law?
As my understanding is that you're asking me to give my view on a potential hypothetical, and that's something that each of the 8 justices currently sitting on the Supreme Court, when they were sitting in my seat, declined to decide potential hypothetical cases. I can tell you about the U.S. v. Nixon precedent, and I did, about Chief Justice Burger's role in forging a unanimous opinion, and really all the justices worked together on that. But Chief Justice Burger, who had been appointed by President Nixon, writes the opinion in U.S. v. Nixon, 8-0, Rehnquist was recused, 8-0, ordering President Nixon to disclose the tapes in response to a criminal trial subpoena. A moment of crisis, argument, I think July 8th, 1974, they decided 2 weeks later. Really important opinion. Moment of judicial independence, important precedent of the Supreme Court. But how that would apply to other hypotheticals, I best, as a sitting judge and as a nominee, follow the precedent of the nominees who've been here before, and as a matter of judicial independence, not give you a precise answer on a hypothetical that could come before me.
Understand. Thank you very much for being forthcoming. Appreciate it.
Thank you,
Mr. Chairman.
You want, I assume you want to reserve your 3 minutes?
Can I do that?
Yeah.
I will.
Senator Hatch.
Well, thank you, Mr. Chairman. Before I begin, I'd like to enter into the record 3 letters and an op-ed supporting Judge Kavanaugh's confirmation. The first letter, which I mentioned yesterday in my opening statement, is a letter from 41 attorneys who are members of the Supreme Court Bar. The signers include people like Lisa Blatt, Deanne Maynard, and Kathleen Sullivan. As the letter notes, the signers, quote, hold a broad range of political, policy, and jurisprudential views, but they speak as one in supporting Judge Kavanaugh's nomination, unquote. The letter authors write, quote, based on our experience with Judge Kavanaugh and his work over 12 years of distinguished judicial service, we are confident that he possesses the character, temperament, and intellect that will make him an asset to our nation's highest court, unquote. Now, the second letter is from Carolyn Williams, a partner at the venerable D.C. law firm Williams & Connolly, who served on the ABA's Standing Committee on the Federal Judiciary. She writes that she has followed Judge Kavanaugh's legal career since 1990, when she was the hiring partner at the firm, and he was a law student. Ms. Williams says that Judge Kavanaugh, quote, has all the qualities litigants and lawyers hope to find in a Supreme Court justice: superb intellect and legal acumen, fundamental fairness and decency, abiding respect for precedent, and the rule of law, unquote. Now, I also want to enter to the record a letter and op-ed by Jay Lefkowitz. The op-ed appeared in National Review and is entitled, Brett Kavanaugh is a Mensch. In it, Mr. Lefkowitz writes that Judge Kavanaugh, quote, has a strong commitment to protecting Americans' freedom of religion, no matter what their faith, unquote. And Mr. Lefkowitz should know, he and Judge Kavanaugh worked together in private practice on a pro bono religious freedom case representing a Jewish synagogue in Maryland. And they won the case, vindicating the right of the congregation to build a place of worship in their neighborhood. Now, let me just begin with this. Before I begin, Judge, I'd like to ask you to keep your answers to my questions as concise as you can so I can get through as many of them as time allows. Some of my colleagues have suggested that President Trump nominated you because he thought you'd rule in his favor should certain issues come before the court. Suppose you had a case involving President Trump or an issue near and dear to the president. What assurances can you provide that you will not allow the president's personal views on a case or personal interest to impact your decision?
Senator, I'm an independent judge. For 12 years, I've been deciding cases based on the law and the precedent in each case. If confirmed to the Supreme Court, that's how I'll do it as well. I'll be part of a team of 9. I'll decide cases based on the Constitution, the law, the precedent, the Supreme Court, working with the other 8 justices, without fear or favor, independently, without pressure from any quarter, The person who has the best arguments on the law and the precedent is the person who will win with me.
Well, thank you. If at the end of the process, of this process, you are confirmed to the Supreme Court, which I expect you will be, what sort of loyalty will you owe to the president? How will that loyalty differ from the loyalty you owe to, say, the American people?
Senator, if confirmed to the Supreme Court and as a sitting judge, I owe my loyalty to the Constitution. That's what I owe loyalty to. And the Constitution establishes me as an independent judge, bound to follow the law as written, the precedents of the Supreme Court as articulated, subject to the rules of stare decisis, and I would do so.
Okay, you were appointed to the D.C. Circuit by George W. Bush. I think it's fair to say you were close to President Bush. You worked for him for a number of years. Can you give us some example of cases in which you ruled against the Bush administration, notwithstanding that President Bush was the one who put you on the bench?
Senator, the most prominent example is the Hamdan case.
Yeah.
That was the military commissions case. That was a signature prosecution of the Bush administration. They had established with congressional authorization eventually, after a unilateral effort didn't succeed in the courts, established military commissions. The military commissions were to try al-Qaeda terrorists who had committed war crimes. And one case came to us, Salim Hamdan, and the question was the prosecution unlawful because the crime of which he was convicted was not an identified crime as of 2001 when he was alleged to have committed it, ex post facto principles. And I wrote the opinion reversing his conviction, even though it was a signature prosecution of the United States, even though it was a national security case, because that was the right answer under the law, and it doesn't matter who you are or where you come from. If you're right under the law, you prevail.
I'd like to turn now to your work in the Bush administration. As you know, my Democratic colleagues are demanding to see every piece of paper or every single scrap of paper you ever touched during your 6 years in the Bush administration, in part because they want to know what role, if any, you played in developing the Bush administration's interrogation policies. Well, 6 years ago, Ranking Member Feinstein, who was then the chairman of the Senate Intelligence Committee, and a good one at that, issued a lengthy report on the CIA's detention and interrogation program under President Bush. The report detailed the origins, development, and implementation of the program. In 2014, a declassified version of that report was released to the public. The declassified version, or report, runs well over 500 pages, and your name appears nowhere in it. Now, I myself spent over 20 years on the Intelligence Committee. I know the quality of its staff and the work that they do, and I know the ranking member and how diligent she is. If you had played a role in the Bush administration's interrogation policies, I think the ranking member would have discovered it. Numerous administration lawyers appear in the report, but not you. And that should tell us something. With that said, Judge Kavanaugh, I want to ask you for the record, what role, if any, did you play in developing or implementing the Bush administration's detention and interrogation policies?
Well, the policies that are reflected and described in Senator Feinstein's extensive, thorough report were very controversial, as you know, Senator. The enhanced interrogation techniques,
right.
And the legal memos that were involved in justifying some of those techniques also were very controversial when they were disclosed in 2004. And I was not involved. I was not read into that program, not involved in crafting that program, nor crafting the legal justifications for that program. In addition to Senator Feinstein's report, the Justice Department did a lengthy Office of Professional Responsibility report about the legal memos that have been involved to justify some of those programs. My name's not in that report, Senator, because I was not read into that program and not involved. There were a number of lawyers, and this came up at my last hearing, a number of lawyers who were involved, including a couple who were then judicial nominees. And at my last hearing, I recall Senator Durbin asking about whether I also was likewise involved as these other judicial nominees had been. And the answer was no, and that answer was accurate. And that answer has been shown to be accurate by the Office of Professional Responsibility report, by Senator Feinstein's thorough report. And I do want to say on Senator Feinstein's report, that is an important piece of work that collected facts about a program, that it's important for us to know those facts for the future. And I know it was an enormous effort and a lot of tough work to get all that information for Senator Feinstein and the Intelligence Committee. But I have looked through that report and looked through the Office of Professional Responsibility report. I was not read into that program, Senator. Thank you for asking.
Okay. Judge, you've been accused of misleading this committee during your 2006 confirmation hearing regarding your role in developing the Bush administration detention policy. Now, you have a strong reputation in the legal community for honesty and integrity. Read any one of the dozens of letters we received supporting your nomination, and you'll see that right away. Now, some of my colleagues may not give you the opportunity to answer this question fully, so I'd like to give you the opportunity now. Did you mislead this committee in 2006? If not, what is the source of the confusion about your prior testimony?
I told the truth and the whole truth in my prior testimony. I was not read into that program. The subsequent reports of Senator Feinstein and Office of Professional Responsibility show that. And that is what I did then. That's the answer now. I was not read into that program.
Okay, as I mentioned in my opening statement, 18 of your former women law clerks have written to the committee in support of your nomination. That's all of your former women law clerks who were not precluded by their current or pending employment from signing the letter. Now, these women describe the mentoring and encouragement you've given them in their careers. And they say that you are, quote, one of the strongest advocates in the federal judiciary for women lawyers, unquote. Quite a compliment. The majority of your clerks, in fact, have been women. Now, I understand that you were the first judge in the history of the D.C. Circuit to have an all-female class of clerks. Why do you believe it important to encourage young women lawyers and to ensure that both men and women are well represented in the legal profession?
Senator, I believe in equality. Equality for all Americans, men and women, also regardless of race, ethnicity. My mom was an example, as I described yesterday, of breaking barriers, showing me first on racial equality by her example of teaching at McKinley Tech. Then, when she became a lawyer in the late 70s, there were not many women prosecutors at the time, definitely male-dominated, and how she overcame barriers, was a great prosecutor, became a state trial judge in Maryland, appointed by Democratic governors. She showed me by her example the importance of women's equality. During college, you've received a letter from 10 college friends of mine who are women athletes at Yale. Talked about how I treated them in women's sports with respect and as equal, even when I was in college. You have a letter from 84 women I worked with in the Bush administration who talked about my efforts to work with them in the tense environment of the West Wing, especially after September 11th.
Did you say 84?
84 women signed a letter who had worked in the Bush White House, and worked in that tense environment. But I came to be a judge in 2006, May 2006. And August 2006, Linda Greenhouse of the New York Times runs a story in the New York Times about the scarcity of women law clerks at the Supreme Court that year. There were 7, I believe, that year out of 37. And she wrote a story about that. And that seemed to me very odd and unacceptable. And I started thinking about what I could do. First of all, why is that happening? And what can I do about it? What's the problem? What can I do? So the problem seemed to me these networks that judges rely on for clerk hiring, some professor networks, were excluding women, or at least women weren't fully represented in those. That's true with minorities as well, by the way. And so I made sure when I was talking to professors at law schools that I made sure I want to see a broad pool of well-qualified applicants, including women. And in that year, for example, fall of 2006, which was my first year on the bench, we hire a year ahead, so I'm hiring for 2007. And I hired 3 women for that clerk class, 2007, 3 out of the 4. Zena Bash, Britt Grant, and Porter Wilkinson. Zena's right here. That was the start of my efforts to make sure that women were not being excluded. And I really worked on why is this happening. So Yale Law Women did a study about 5 years ago about participation in class, the differences on who gets called on in class. And there's slight differences there, men and women, who then get selected as research assistants, slight differences there, and it just keeps building till you get a disparity in the clerk network. And there's a pipeline problem, and I've said I'm breaking through that problem. I'm not listening to that. And so I've been very aggressive about hiring the best and understanding that the best include women. And as you say, Senator, a majority of my clerks have been women, 25. I believe 21 of them have gone on to clerk at the Supreme Court. And they're an awesome group. And if confirmed to the Supreme Court, I will continue to do this. What it takes, and I think my mom showed me this, President Bush showed me this a little, what it takes is just not accepting the same old answer. Oh, there's a disparity. Well, why? And then do something about it. And I try to figure out why, and we can talk about minority clerks too, but on women, why were those disparities existing as described by Linda Greenhouse? And I tried to figure out why, and then I did something about it. I'm very proud of that because I do believe that all people should be treated equally, and the law clerk position, which may sound ministerial, and to some extent the job is helping the judge and shortly out of law school, but those positions are very important launching pads for the next generation of leaders. The people will be sitting in these seats. The people will be sitting in my seat. Lots of them are going to come from law clerks. So if we're not being inclusive now, that will show up later. And so it's just been a critical part. It's something I'm very focused on at all times, is equality in the clerkship hiring process and making sure women are getting the same opportunities that men are. I appreciate the question, Senator.
Well, thank you, and I appreciate the answer. And I think everybody in this country should appreciate the answer. And I think it distinguishes you. Late last year, allegations against former Ninth Circuit Judge Alex Kozinski surfaced when the Washington Post published an article detailing disturbing allegations of misconduct by the judge. You clerked for Judge Kozinski for 1 year in 1991, 1992. Some of your opponents have suggested that you must have known about these allegations. This seems to me to be an effort at guilt by association, which is not the way this committee should operate in any way. With that in mind, I want to give you a chance to answer a few questions about Judge Kaczynski so that we're all operating on the same foundation of facts. First, how long have you known Judge Kaczynski?
I clerked for him in 1991-92, so I started the clerkship 27 years ago.
Second, I understand from media reports that Judge Kaczynski operated an email list where he would send inappropriate material. Were you on this email list?
I don't remember anything like that, Senator.
How often did you talk with Judge Kaczynski on the phone?
Not often. Not often, Senator.
How often did you see him in person?
Again, not often. Maybe when there was a legal convention or...
That's what a lot of people don't seem to understand, you know.
I was not working in the courthouse. He was in the Pasadena courthouse in California with small courthouse with 10 other Court of Appeals judges in that courthouse. I, of course, was working in Washington, D.C.
When you did see and talk with Judge Kaczynski, what type of things did you talk about?
We were among the 12 co-authors of the Brian Garner-led book on judicial precedent. So for several years, that was a project all of us were, the 12 of us, I guess it was in total, were working on that. Diane Wood, Chief Judge of the Seventh Circuit, and Justice Gorsuch was also a co-author, so we worked on that as a group. And then Justice Kennedy, for the last 30 years, had Judge Kaczynski run Justice Kennedy's law clerk hiring process, and in the course of that process, I would have communications with the judge.
Okay. Did you know anything about these allegations?
Nothing.
Okay. Before they became public last year?
No. When they became public, you know, the first thought I had was no woman should be subjected to sexual harassment in the workplace, ever, including in the judiciary, especially in the judiciary. And when I heard, when they became public, I think it was in December, it was a gut punch. It was a gut punch for me.
It was for me, too.
It was a gut punch for the judiciary. And I was shocked and disappointed, angry, swirl of emotions. No woman should be subjected to sexual harassment in the workplace. And I applaud Chief Justice Roberts' appointed committee of judges to establish better procedures. Chief Justice Garland did the same thing for our court. And those are first steps. I don't think they're final steps by any stretch. And this is part of a much larger national problem of abuse and harassment. And one of the things we've learned is we need better reporting mechanisms. Women, in particular in the workplace, need to know if they're the victim of harassment, where to report it immediately, who to report it to. They need to be know that they'll be safe if they report it. They need to have a safe working environment and be safe if they report it. They won't be retaliated against, and they'll be protected if they report it. And that's part of the steps, or one of the steps that's, I think, being improved as a result of the working group or committee that the Chief Justice has appointed. And I'm interested in doing everything I can to assist those efforts to make those workplaces safe. Again, it's part of a broader national problem, whether it's priests or teachers or coaches or doctors or business people or news people. There's a broad national problem that needs to be addressed, including in the judiciary, and
Okay.
I applaud Chief Justice Roberts for doing so.
Okay, I'd like to talk to you now about the Chevron doctrine. Now, this is an important judicial doctrine that takes its name from the Supreme Court case that created it back in the 1980s. In that case, the Supreme Court instructed federal courts to defer an agency's interpretation of the law if the law is, quote, ambiguous, unquote. Some of your academic writings express skepticism about the Chevron doctrine and concern that it allows an administration to impose its policy preference by avoiding the political process. I can understand why this would be appealing to an administration, but I also think it's a threat to the separation of powers because it transfers power from Congress and the judiciary to the executive branch. That's why I've introduced the Separation of Powers Restoration Act to reverse the Chevron doctrine. Many members of this committee have co-sponsored this legislation. And as someone who has written extensively about the separation of powers, can you tell us why the separation of powers is so important and how it helps to protect individual freedom?
The separation of powers protects individual liberty because it responds to the concern the framers had, that something Senator Klobuchar said yesterday from Federalist 47, that the accumulation of all power in one body would be the very definition of tyranny. So Federalist 47 talks about that, Federalist 69. So the separation of powers, to begin with, protects individual liberty. It does so because Congress can pass the laws, but you can't enforce the laws. A separate body has to decide to enforce the laws. And then even if the law is enforced, and a citizen may say, well, I want someone who didn't pass the law or enforce it to decide whether I violated the law or whether the law is constitutional. And that's why we have an independent judiciary to guarantee, as an independent matter, our rights and liberties. And the three branches, therefore, do separate things because it all tilts toward liberty. It's hard to pass a law, as you know, in the Congress. And then, even if it does get passed and affects your liberty, a separate body has to decide, usually U.S. Attorney's Office, to enforce the law, and that's a separate decision. That helps protect your liberty. And then even if that happens, you go to a court and you say, either I didn't violate that law, as I'm accused of doing, or that law is unconstitutional, or they're interpreting that law in a way that's not consistent with what the law said. The court independently decides that. It's not the members of Congress or the executive deciding that. That's how the Constitution's separation of powers tilts toward liberty in all its respects. Now, as to your specific question, Senator, one of the things I've seen in my experience in the executive branch and in the judicial branch is a natural tendency, but it's a natural tendency that judges need to be aware of and then respond to. So here's the natural tendency. Congress passes laws, but then can't update the law. So maybe it's an environmental law, or maybe it's some kind of law dealing with national security. Let's take those two examples to illustrate. And then an executive branch agency wants to do some new policy and proposes a new policy to Congress, but Congress doesn't pass the new policy. What often happens, or too often I've seen, is that the executive branch then relies on the old law as a source of authority to do this new thing. And they try to say, well, the old law is ambiguous, so we can fit this new policy into the old law as justification for doing this new thing. And I've seen this in national security cases. I've seen it in environmental cases. You see it all over the place. It's a natural phenomenon because the executive branch wants to implement what it thinks is good policy. Now, when those cases come to court, it's our job to figure out whether the executive branch has acted within the authority given to it by Congress. Have you given them the authority? And my administrative law jurisprudence is rooted in respect for Congress. Have you passed the law to give the authority? I've heard it said that I'm a skeptic of regulation. I am not a skeptic of regulation at all. I am a skeptic of unauthorized regulation, of illegal regulation, of regulation that's outside the bounds of what the laws passed by Congress have said. And that is what is at the root of our administrative law jurisprudence.
Okay, one of the most important qualities I look for in a judicial nominee is the ability to impartially interpret the law and apply it to the case before the court. Now, this can often be the most difficult part of a judge's job because it may require the judge to rule against a litigant that may be sympathetic or against a policy that the judge may personally agree with. As Justice Sotomayor's confirmation hearings, Senator Schumer commended her for, quote, hewing carefully to the text of statutes, even when doing so results in rulings that go against so-called sympathetic litigants, unquote. Do you believe that it's important for a judge to interpret and apply the laws that Congress has actually passed, rather than seeking to make up or change the law if the judge doesn't like what the Congress has done? And if so, why or why not?
I agree completely, Senator. That's at the foundation of what I view as the proper judicial philosophy.
Okay.
The separation of powers system you described, we have to stick to the laws passed by Congress. You make the policy, we'll follow the policy direction that you put into the laws that are enacted, passed by the House and Senate, signed by the President. We don't rewrite those laws. The executive branch also shouldn't be rewriting those laws beyond the scope of the authority granted.
Okay, some of my colleagues have criticized you for purportedly ruling too often against environmental interests. It seems to me that many of these circumstances boil down to the fact that some of my colleagues don't like the environmental laws Congress has actually passed and are frustrated that they haven't been able to get their own preferred environmental policies signed into law. Now, I've looked through your record, and I found that you have not hesitated at all to uphold environmental regulations when they were actually authorized by statute. Could you give us a few examples of cases where you have upheld environmental regulations because you concluded that Congress had authorized them?
Limited to as many few as you can as time has run out.
Senator, as I said yesterday, I'm a pro-law judge, and in environmental cases, in some cases I've ruled against environmentalist interests, and in many cases I've ruled for environmentalist interests, and they're big cases, cases like the American Trucking Association's case, where I upheld a California regulation for a majority over a dissent, stricter air quality standards in the National Association of Manufacturers case, EPA rules for particulate matter in the UARG case, permit process applicable to surface coal mining in the National Mining Association case, the Murray Energy case rejecting a premature challenge to a Clean Power Plan regulation, the National Resources Defense Council case versus EPA, ruling for environmentalist groups. In a case, that was a big money case where the industry wanted an affirmative defense to be created for accidental emissions. The affirmative defense was not in the statutes passed by Congress. The industry came in with their lawyers and said, well, just write the affirmative defense into the law. And I wrote the opinion saying, no, it's not in the law. And yes, that might be a problem for industry, but we follow the law regardless. And so there are a large number of cases where I've ruled in favor of environmentalist interests because that's what the law required in that case.
Well, thank you, Judge. I appreciate it.
Thank you, Senator.
Senator Leahy.
Well, thank you, Mr. Chairman, and good morning, Judge.
Thank you, Senator.
You and your family. We have a lot of questions, and I know you've done a lot of preparation with a couple of our distinguished Republican colleagues about the questions you might be asked. But let me ask you something that normally isn't an issue during Supreme Court hearings. You testified before this committee in both 2004 and 2006 as part of your nomination to the D.C. Circuit Court. Then you were nice enough to come by my office and chat with me last month. I asked you that if you changed anything in your prior testimony, and you said no. Is that still your position?
It is, Senator. I told the truth. I was not read into the programs.
No, I'm not asking about what we did, but I just asked you if you would change anything in your...
Well, I'd like to explain if I can.
Well, I'm going to give you a chance because I'm going to ask you a couple questions. Go ahead.
Well, I just wanted to explain that at the last hearing in 2006 in particular, you were concerned, understandably, because there had been two judicial nominees who had been involved in the legal memos in the legal discussions around crafting the enhanced interrogation techniques and detention policies. You were concerned whether I also was involved in those. And I made clear in response to those questions that I was not read into that program. That was 100% accurate. It's still accurate today. I think Senator Feinstein's report and the Office of Professional Responsibility report established that I was not involved in those programs. Now, there were two judicial nominees.
Okay, I'm going to go into that in a little bit. I don't want to go over my time as the preceding senator did. I want to stay with.
Well, Senator, I just want to be clear. I want to reassure you.
I'm going to go into it. I'm going to give you a chance to speak a lot more.
Without
But let me.
Hey, I'm not going to take time away from you, but I want to explain something. I said yesterday that if a question is asked within the 30 minutes, that he can finish the question and it can be answered. So he did not go over his time.
So I didn't mean to hit a sensitive area. Let me ask you this: between 2001, I'm new here. Between 2001 and 2003, 2 Republican staffers on this committee regularly hacked into the private computer files of 6 Democratic senators, including mine. These Republican staffers stole 4,670 files, and they used them to assist in getting President Bush's most controversial judicial nominees confirmed. Now, the theft by these Republican staffers became public in late 2003 when the Wall Street Journal happened to print some of the stolen materials. The ringleader behind this massive theft was a Republican staffer named Manny Miranda, who had worked for one of the members of this committee. In a way, it was considered by many, both Republicans and Democrats, as a digital Watergate, not a theft not unlike what the Russians did in hacking of the DNC. Now, during all this, you worked hand in hand in the White House with Manny Miranda to advance these same nominees where he was stealing material. Not surprisingly, you were asked extensively about your knowledge of this theft during both your 2004-2006 hearings. And I don't use the word extensively lightly. You were asked over 100 questions from 6 senators, both Republicans and Democrats. And you testified repeatedly that you never received any stolen materials. You knew nothing about it till it was public. You testified that if you had suspected anything untoward, you would have reported to the White House counsel, who would have raised it with Senator Hatch, especially as Mr. Miranda had worked for him. And at the time, we left it there. We didn't know any better. Today, with the very limited amount of your White House record that has been provided to this committee, and it is limited, for the first time, we've been able to learn about your relationship with Mr. Miranda and your knowledge of these events. So my question is this: did Mr. Miranda ever provide you with highly specific information regarding what I or other Democratic senators were planning on asking certain judicial nominees?
Senator, well, let me contextualize, because I'm looking at what you're putting up here first in the renewed.
Thank you.
Well, the question.
So that what's up there is 100% accurate. That's my memory.
Okay, so let me ask you this. That's
never knew or suspected. True. Never suspected anything untoward. True. Had I suspected something untoward, I would have talked to Judge Gonzalez.
And I've already
would have talked to Senator Hatch. That's all 100% true.
And that's what I had already said. But did Mr. Miranda ever provide you with highly specific information regarding what I or other Democratic senators were planning in the future to ask certain judicial nominees?
Well, one of the things we would do as a White House is on judicial nominations, and I'm coming to your answer, but I want to explain, is to meet up here, and this happens on both sides all the time, with teams up here about, okay, their judicial nominations, our judicial nominees are coming up, how are we going to get them through? Here's a hearing coming up. And during those meetings, of course, it would be discussed, well, I think here's what Senator Leahy's going to be interested in. That's very common. I'm sure in President Obama's administration, when they had similar meetings, they would probably have meetings and say, well, I think this is what Senator Graham will be interested in. That's what you do in meetings with, so highly specific would, I think, I'm not sure what you're getting at by highly specific.
I've been here over 40 years. I know what both Republican and Democratic administrations do in preparing. I'm not asking about that. I'm asking you, why before this did Mr. Miranda send you an email asking you on July 19, 2002, asking you and another Bush official why the Leahy people were looking into financial ties between two special interest groups and Priscilla Owen, a particular controversial nominee to the Fifth Circuit? You would handle that Owen nomination. As you know, as a judge, she had received a lot of contributions. Well, did Mr. Miranda send you an email asking you why the Leahy people were looking into her financial ties?
Is that what this email is?
I'm just asking you.
Well, can I take a minute to read it?
Of course.
Okay.
This incident was 4 days before her hearing on July 23rd.
Did I send any of the emails on this chain? I don't think so. I think I'm CC'd. In any event, if he said, why are the Leahy people looking into this? From Manny Miranda. I don't really have a specific recollection of any of this, Senator, but it would not have been at all unusual for, and this happens all the time, I think, which is the Leahy people are looking into this and the Hatch people are looking into that. I think.
You say all the time, 2 days before the hearing, he told you that the Democrats were passing around a related 60 Minutes story, and he said his intelligence, suggests that Leahy will focus on all things money. Well, that appears to come from a stolen email to me, stolen by the Republican staff member, sent to me the night before, and then given to you the next morning. Mm-hmm. Were you aware that you were getting from Mr. Miranda stolen emails?
Not at all, Senator. It was part of what appeared to be standard discussion about, it's common, Senator, for at the White House, it'd be common to hear from our Leg Affairs team. This is, in fact, in this process, it's common to hear. This is what Senator X is interested in. This is what Senator Y is going to focus on.
Was it common to have copies of a private email sent to a particular senator?
Copies of a private email sent to a particular senator?
Yes. Wouldn't that jump out at you?
For example, what are you referring to?
Well, Mr. Miranda is telling you about emails sent to me the night before. There'd be no way that he would even have that unless he stole it. Did that raise any question in your mind?
Did he refer to that email in this?
Yes.
And where is that, Senator?
I'll let you read it.
Well, I'm not seeing where you're... I'm not seeing what you're referring to.
Yeah, it's not here.
Okay. Well, let me take you one that you do have. because you do have this information from Mr. Miranda, and the very limited amount of material that the Republicans are allowing us to see of your information about you, that at least did come through. But in January 2003, let me go to something very specific. Mr. Miranda forwarded you a letter from me and other Judiciary Democrats to then Majority Leader Tom Daschle. The letter was clearly a draft. It had typos and it wasn't signed. Somebody eventually, we never put it out, but somebody eventually leaked its existence to Fox News. I'm not sure who, I could guess. It was a private letter. At the time I was shocked to learn it existed. It had been leaked, but here's the thing. You had the full text of my letter in your inbox before anything had been said about it publicly. Did you find it at all unusual to receive a draft letter from Democratic senators to each other before any mention of it was made public?
Well, the only thing I said on the email exchange, if I'm looking at it correctly, Senator, was who signed this, which would imply that I thought it was a signed letter.
It was sent to you. Were you surprised to get it? I mean, it's obviously a draft. It's got typos and everything else. Were you surprised the draft letter circulated among Democrats ended up in your inbox?
But
from Mr. Miranda.
I think the premise of your question is not accurately describing my apparent recollection or understanding of the time, because I wouldn't have said who signed this if I thought it was a draft. And my email says who signed this.
So you didn't realize what you had was a stolen letter signed by me, that you had a letter that had not been sent to anybody, had not been made public?
Well, all I see that I said was who signed this. That's all I see.
Well, let me ask you some more, because so much of this came from Mr. Miranda, who was a Republican staffer who was, as we now know, stealing things. Did he ever ask to meet privately with you at an off-site location somewhere other than the White House or Capitol Hill?
I think sometimes, Senator, that the meetings with Senate staffers and White House and Justice
I'm
Department.
just asking about one particular one, Mr. Miranda.
Yeah, sometimes, usually it would be either at the White House or the Senate, but I think sometimes we'd meet, or DOJ, but sometimes it could be somewhere else.
Well, did he ask to meet with you privately so he could give you information about Senator Biden and Senator Feinstein?
I'm not remembering anything specific, but that's certainly possible. And again, Senator, I just want to be clear here, because it's very common when you're in judicial selection process to determine what are all the senators interested in for an upcoming nominee or an upcoming hearing. That is the coin of the realm. Senator X is interested in focusing on administrative law. Senator Y is going to ask about environmental law. Senator is concerned about your past work for this client. And that's a very common kind of discussion.
Did he ever ask to have you meet him, not the White House, not at the Capitol, but at his home?
I don't remember that.
Okay. Did he ever ask to meet you outside of the White House or the Capitol?
I can't rule that out, but again, that wouldn't have been typical.
Did he ever hand you material separately from what would be emailed back and forth?
Not remembering what if you're referring to something in particular, I can answer that.
Okay,
But
well, let me ask you this. Did you ever receive information via Mr. Miranda, information marked confidential that informed you what my staff was sharing with other Democrats?
I don't know the answer to that, Senator, but again, people it's not always the case, at least my understanding, that the people on, for example, your staff and Senator Hatch's staff were necessarily working at odds. It seemed like a lot of times the staff was cooperating at times, not at other times, obviously, but at times about judicial nominations. And so it wouldn't have raised anything in particular in my mind if we learned, oh, Senator Leahy's concerned about this.
Did my staff ever send you confidential material from Senator Hatch that was stolen from his emails?
Well, not the last part, but I certainly did talk to your staff when we were working on the airline bill, on the September 20, 2001 airline bill. I did remember being here all night one night with your staff, and I'm sure we did talk that night about what other senators thought, and that was the airline bill where, as I think you recall, Speaker Hastert was involved, and we were up there with the OMB team. So in that, I worked hard with your staff on that. It just struck me as not uncommon at all to be talking with our ledge team about what senators on both sides think. It didn't strike me that it was always armed camps.
But no, and oftentimes it was not. But here you're getting obviously very private Democratic emails. You weren't concerned how Mr. Miranda got them?
Well, I guess I'm not sure about your premise.
Were you at all concerned about where Mr. Miranda got some of the material he was showing you?
I don't recall that, but on the premise of your last question, I want to step back to that. Not sure I agree with the premise.
I just say, if you're getting something that's marked confidential, wouldn't you assume that's not something being shared back and forth?
Unless it was shared. I mean, this is the thing. If a staffer said, "Here's what we're sending to," you all should be aware of this because we're going to make we're going to be really opposed to this judicial nominee. So just to be clear, it seemed to me sometimes there were judicial nominees you were very opposed to, sometimes you were supportive of, and sometimes in between, and there would be messages passed back and forth and sharing of information. Very cooperative, as I recall.
Well,
you were transparent. In other words, when you had problems with nominees, I recall transparency, and when you were supportive, you were at the May 9th, 2001 event at the White House, I recall, where the president announced his first 11 Court of Appeals nominees, and you were supportive of many of them.
Well, as you know, yeah, but as a fact, I voted for a lot of Republican nominees.
Yes.
Both to the Supreme Court, the Courts of Appeals, and the District Court.
Yes.
But when I've opposed one, like with Judge Owen, when I was raising some very questions about funding that she was getting from people that were before her court, that might have raised a red flag that I had some concerns about her. Now, when you worked at the White House, did anyone ever tell you they had a mole that provided them with secret information related to nominations?
I don't recall the reference to a mole, which sounds highly specific, but certainly it is common. Again, and the people behind you can probably refer to this, but it's common, I think, for everyone to talk to each other at times and share information. At least this was my experience. This is 20 years ago almost, where you would talk to people and the committee.
You never received an email from a Republican staff member with information claiming to come from spying on Democratic mole?
I'm not going to rule anything out, Senator. But if I did, I wouldn't have thought that anything. I wouldn't have thought that the literal meaning of that. But
wouldn't it surprise you that if you got an email saying you got that from somebody spying on Democrats?
Well, is there such an email, Senator? I don't know. I mean,
well, we'd have to ask the chairman what he has in his confidential material.
But here's the, if you're referring to something particular, here's what I know.
Hey, just stop a minute here. Reference twice in your 30 minutes, and don't take this off of his time. you made reference. You're talking about the period of time that he was White House counsel.
Yep.
That material's available to everybody.
So that bit of the material about him that's marked committee confidential is now public and available? Is that what you're saying? If that's what the chairman's saying, we got a whole new series of questions.
No, not if it's committee confidential, but
So it's not available.
you have access to it.
Not so that
But
I
don't
can
forget, 80% of the material we've gotten from the library is on the website of the Judiciary Committee, so the public has access to it.
No,
Proceed.
I want Judge Kavanaugh to have access so that we can ask him these questions under oath and he can see them. So I would ask and we'll have another round, but I would ask the chairman if he might look at some of these that are marked committee confidential, which limits the ability of us to ask you specifically and hand you the specific emails. But I would state on what has been public.
Let me answer that for you. There's only one Democratic senator asked for access to that. Senator Klobuchar got it. If you're interested in it, you could have been asking ever since August the 25th, I believe.
We've been asking to have that, those made public. I'm not as interested if I see this in a closed room where I can't talk about it. I want Judge Kavanaugh to see the emails which came from Mr. Miranda
Give us a citation of the documents and we'll get them for you.
That
And we'll make
testimony
it
up
public.
there is true, 100%.
Can somebody read it? You can't see it. What?
Of course, it would be helpful if we'd allowed the National Archives time to complete their review.
But I just want to reassure you, Senator, because you're asking important questions. I want to reassure you that what you've got up on the board is 100% accurate.
Can somebody move it so we can see it here?
Well, I am concerned because there is evidence that Mr. Miranda provided you with materials that were stolen from me. And that would contradict your prior testimony. It's also clear from public emails, and I'm restraining from not going into the non-public ones, that you had reason to believe materials were obtained inappropriately at the time. Now, Mr. Chairman, there are at least 6 documents that you consider committee confidential that are directly related to this. Just like the 3 documents I shared, they're already public. These other